Perfect. So Pauline, whenever you're ready.
Good. Thank you everyone for joining Around the World with TJ today. I'll start. I'm in Victoria, Australia, in Melbourne. I'll start by acknowledging the traditional owners of the land on which I am today, the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to the elders past and present. They have cared for this land and waterways for millennia, and their sovereignty has never been ceded. In the words, in the language of the Wurundjeri people, Wamanjenka, welcome to this seminar today on the topic of everyday judging in a therapeutic key. I'm a magistrate or a judicial officer judge of the Magistrates Court of Victoria. For thinking internationally, we translate to local courts or provincial courts. We have a very broad jurisdiction across both what we call summary and indictable, or up to felony, misdemeanor and felony criminal offences. Another big part of our work is a protection jurisdiction for domestic or family violence. And we also have a civil jurisdiction as well. But as a magistrate in our court, the bulk of my work that I am doing is criminal law, and we don't have jury trials, so I am deciding law and facts, and also the bulk of my work would be applications for bail when someone has been not released upon arrest and remanded in custody, so consideration of whether or not they are bailed pending the determination of their case. And also the other big part of my work is sentencing. The bulk of the matters that come to our court do resolve with quite rigorous case management, either with being dropped by prosecution along the way, or resolving in some satisfactory manner to a plea of guilty for the accused person. So our jurisdiction is a very busy court, high volume. Every case, whether it's a case that's on its way to a higher court for a jury trial, starts with us. And so we're very busy. So there's the mainstream criminal jurisdiction, and then we have a range of specialist courts as well that deal with particular cohorts of people, such as our Koori courts. They are our Indigenous sentencing courts throughout the state, or our specialist courts deal with people with greater complexity or risk that require a more intensive intervention, such as our assessment and referral court, which is for people with mental impairments, and they are being rolled out now across our state, and also drug court, which is for people who would otherwise be serving a term of imprisonment who are released on a drug and alcohol treatment order. So it's a very broad jurisdiction, and what I want to talk today is about judging in a therapeutic key, picking up on one of our TJ elders, the work of Bruce Winnick, who's now passed, and the wonderful David Wexler, who coined the term with the seminal text, judging in a therapeutic key. And I really like talking about judging in a therapeutic key because it is first and foremost judging. And as judges, we as judicial officers, we judge according to law. So that's really important to remember, that we're not throwing out law or due process, that we are, however, thinking about how we are doing our roles as legal actors and putting a therapeutic lens over that. So we are judging, but we are judging in a therapeutic key. Just want to think about the types of people who are coming before us in our courts, and anyone who works in the criminal law streams across the world. I think we all maybe experience these same issues. People are coming obviously to the court because of a legal issue, but more often than not, we know that there are other issues going on for them, either personally or systemically or both, that are impacting upon them and often intersecting or driving the legal issue that's presenting at the court. For example, thinking about the last couple of days, I've had people in my court who are people with intellectual disability that have experienced child sexual abuse and trauma, and then developed alcohol and drug abuse as a coping mechanism for that trauma that they're experiencing, homelessness and poverty, because they're excluded from employment. And they also, this person was a First Nations person who was experiencing the impacts of colonisation. So in one person, I had all these intersecting issues that are presenting to the court. So in a practical way, when you're being faced with this on an everyday basis, taking a compassionate stance where you not only want to have empathy or feel connection to the person, what they're experiencing, but a compassionate stance calls upon us to think about what we can do about that. That a compassionate stance calls upon us to think about these broader issues in our judging, as well as strictly applying the law and legal process. The other thing is that what we know, just from a criminological point of view, that if we don't deal with some of the drivers of offending, the intervention that we impose, such as a penalty, such as a fine or probation or what we call community corrections orders, or even imprisonment, if we don't deal with the underlying issues, then the impact of that intervention, that legal intervention, is diluted, because the underlying issues are still there, and the chances are that if they're not managed well in the community, or the person's not well supported, that they're going to come back again. And anyone who's worked in the system knows that it's just, you can see it happening, where the same people come back over and over again. So today I want to talk about an aspect of judging in a therapeutic key, and it is only one aspect. As we know, we can judge in a therapeutic key in all aspects of our work, be it from the moment someone walks into our courtroom and we get eye contact and acknowledge them, so that they feel seen, that we listen actively and ask questions about the case, and we do reflective listening back and acknowledge that we've heard someone's submissions, so they feel heard. So all those basic things we can do in our work, the way we deliver our judgments, the way we write our judgments, all these things can be done in a therapeutic key. But today I want to focus on one aspect, which is what we call judicial supervision or judicial monitoring. And that is where a person in the criminal court comes back before the same judicial officer at regular intervals while they're engaging in rehabilitation. Now, this is a key feature of specialist courts. So those of you who know, for example, about drug courts have a person linked with services and treatment, they will have a support team around them, a multidisciplinary team, maybe a clinician, a case manager, maybe a housing worker, a psychologist and alcohol and drug counsellor. So they'll have their team. And then they'll have the judicial officer, and they will have regular check-ins with the judicial officer over time. In our drug court, that happens every week. They come back before the same judicial officer, and they have their team, and they have very that wraparound service, but they're coming before the same judicial officer. In our mental health court, they come back before the same judicial officer every month. So this is a key feature of specialist courts. But what I want to talk about today is this work that is happening in Victoria, Australia, in our mainstream criminal court setting. And it's what I want to refer to and think about as targeted judicial supervision. And as I explained at the outset, in our criminal court, we have tens of thousands of cases. So we have in just one court, many people coming in, hundreds of people coming in every day. And so you just can't, in a high volume court, do judicial supervision in every case, nor should you. And I'll talk about that a little later on, about some of the reasons why you shouldn't do it from a legal and criminological point of view. But in a mainstream court, there is the opportunity to apply therapeutic jurisprudence approach of judicial supervision or judicial monitoring in a targeted way. And that's what I want to talk about today. Now, just thinking about the legal basis of this, how do you do this in a mainstream court? Well, the original legal basis in Victoria, Australia, was the inherent power of the court to control its own proceedings and the power of the court to adjourn a case. As my colleague, Dr. Michael King says, the power of adjournment is one of the great powers of a court. We can adjourn to get more information. We can adjourn for a reason. And in Victoria, where under the Bail Act, it allows us to set conditions upon which someone will be admitted to bail. So it's not just money bail, but it could be that they engage in rehabilitation. A case might come back to court while the person is deciding with their legal representative whether or not they'll plead guilty or not. And so there may be opportunities along the way to check in and see how that bail is going. So the case gets adjourned. In our Sentencing Act, it is a principle of the Sentencing Act in Victoria that one of the sentencing purposes, along with other purposes such as deterrence, denunciation, punishment, and community protection, is the sentencing principle of rehabilitation. So it is allowed to, in our sentencing process, to consider the rehabilitation or facilitating the rehabilitation of the person. And then, so you can see with that coupled with the power of adjournment, allows us to bring someone back to see how they're going before we finally sentence. This is originally how magistrates who saw all those people with the myriad of problems that I talked about at the outset started doing this work in Victoria. They didn't actually have any legislative change. They actually just started doing it, and they did it by using the inherent power of the court to adjourn. Now, as you would imagine, court administrators, where we in high volume courts look at that and go, well, we want to finalise as many cases as quickly as possible for efficiency purposes. So that's where targeted judicial supervision is really important, because you could bring a high volume court to a standstill or create great delays. And of course, delay creates a whole lot of other injustices. So there's a balancing act between efficiency and effectiveness. or quality or court excellence. And if you're interested in that work, Liz Richardson, Dr. Liz Richardson, David Wexler, Professor David Wexler, and I did a piece that's a written piece that's available on SSRN about therapeutic jurisprudence and the international framework for court excellence, where we talk about the concept of therapeutic jurisprudence as a key part of considering what is court excellence. So that was the original legal basis in Victoria. Since this work has been happening in our court, though, we have had some legislative change that does bolster or support this work. So I want to touch on a couple of areas. The judicial supervision in mainstream court where appropriate. So again, it's not always appropriate, but is facilitated by a few sections in our legislation. The Bail Act allows for the setting of conditions of bail, including compliance with bail support services, which then allows for those bail review hearings. So bail review hearings are not actually set out in the Bail Act, but we can set a condition of bail. If it's related to the offending, so it has to have a nexus with the offending, but we can set that condition of bail. The other legislative piece is the Sentencing Act. Our Sentencing Act, as I said, has a provision that it is an accepted sentencing principle to facilitate rehabilitation, community protection and specific deterrence. And I think this sort of work feeds into all those aspects of sentencing under our Act. And we have specific sentencing provisions now, one called the deferral of sentence. So someone can enter a plea of guilty and then we can defer sentence. And it is a principle under the deferral power. There are principles under the deferral power that allow for the purposes of deferral, and they can include to allow someone to demonstrate rehabilitation or even to engage in restorative justice type practices. So what happens is a person is they enter a plea, their sentence is deferred, and then their matter is adjourned for maybe check-ins along the way, and then for final sentencing at a later date. The other Sentencing Act provision that came in that did facilitate judicial supervision post-sentence is under our community corrections order, which is like a probation order in the community where they're supervised by community corrections or probation officers outside of the court, so independent of the court. But the court, when imposing that community corrections order, can set a judicial monitoring condition. So the condition can be set, and then we put a date, and then the person comes back, even though they've been sentenced, they come back for that judicial monitoring hearing. We get a report from community corrections about how they're going, and we can use the techniques of judicial supervision. We can decide how many times we bring them back, how regularly we bring them back, how long that goes on for. So I just want to flag the where appropriate, because this is the first level of targeting. There may be other legislative imperatives that preclude rehabilitation, or the person may be an unacceptable risk and bail may not be granted. And so, for example, where someone might have quite complex needs, but their level of offending and harm to the community is such that the seriousness of the offending and the risk to the community might be that other sentencing principles such as denunciation or general deterrence or community protection or a combination actually means that the only right sentence is for that person to be incapacitated and not be in the community engaging in rehabilitation. So that's really the first level of targeting. And as I said at the outset, judging in a therapeutic key doesn't mean we throw out the law, we actually apply the law, but where appropriate, we can use this approach. I think it's important to think about what the role of the court is. I think we can get caught up in particularly where we're in jurisdictions where there may not be strong community services or a network of community services, that courts end up being a little bit of the ambulance at the bottom of the cliff, and we want to help. And then our tendency is to say, okay, we can provide all these services at a court. But I think we need to be very clear-sighted about what our purpose is as a court, because a lot of things flow from that. And so I think about the court's role. We have a role in managing risk and facilitating rehabilitation. We are a court, that's our legislative role under the Bail Act, under the Sentencing Act. So what is the goal there? The goal, in my view, is to shift the person from offending to managing better in the community with supports, and ideally reducing the risk of reoffending or stopping offending. We're realistic. Often it's reducing the severity and frequency of offending, certainly in the initial stages of the desistance journey. And at that point, whatever that point is, when they are able to be managing a little better in the community, the court can and should step away. So sometimes this can be done easily, and sometimes it takes more intervention. I like to think of it as the bridge analogy. So someone is offending, they're in crisis, things are chaotic, and they're causing harm in the community. They end up before us, and then we are the bridge. Our intervention is the bridge into the community where we try to get them to manage better with supports and hopefully not come back at all, or not come back as regularly or as with greater severity of harm to the community. So we're that bridge. Sometimes that bridge is a little footbridge over a little babbling brook, and that might be a community referral. Sometimes that bridge is a one-lane bridge over a bigger river, where they need a bit of encouragement and support along the way, a bit of accountability to make sure they do engage, and we check. And that's kind of the work we think about in our mainstream court with judicial supervision. And sometimes that bridge is a full expansion bridge over the San Francisco Bay, which is very intense, resource intense and long and challenging. And that might be where people have much more complex needs and are in for example, our drug court or our mental health court. So you can see the different layers. And what are we doing what can the court do to do the bridge? Well, the first thing is assessing need. And so we have a number of opportunities to assess need. For a judicial officer, the first thing is even the person's presentation, then what they're telling you if they're unrepresented, or what the lawyer's telling you, what you're reading in the material that you hear from the prosecution. So you're kind of hearing all this, and you're assessing the need as you go as a judicial officer. But we're also lucky in our court that we do have actual staff in our mainstream court, in our court integrated services program, and a new pilot that we're running called Navigation, where we have non-lawyers who are social work background, alcohol and drug background, housing, disability background, those sorts of from the social sciences. And we have those staff members who can meet with the person outside of the court room and actually do a proper assessment of need. And we also have mental health clinicians as well who can do a need assessment. So we have another number of non-legal staff in our courts who can assess need. But certainly before we had the funding for those positions, the judiciary were just assessing needs by listening and asking questions of the person, of their lawyer, listening to the prosecution and pulling out, well, you can see this person's got an alcohol and drug problem. You talk about some trauma, what's that about? Does your client identify as First Nations? So you can pull out different needs just informally through the process. So the court can assess needs, then the court can connect with community supports. Now, again, we're very lucky. We have staff whose job is to connect with community supports. Then we also have some brokerage arrangements where we have contracts with providers for alcohol and drug provision and housing. So we have some steps into that to community supports. But again, before we had that in Victoria, the magistrates just started doing this by calling in the services that were in the local community and for a meeting and saying, hey, we're all working with the same clients. Is there stuff we can do here? Can we improve our referral pathways? some of them said, yeah, sure, we can send someone to court on a Monday. And it literally started like that. The other thing the court can do is encourage and monitor engagement in appropriate cases, as I said, in targeted cases. So this isn't in all cases, but sometimes that bridge, as I said, needs to be the bridge over the river, and it needs a little bit more, the person needs a little bit more encouragement and monitoring. And we can do that either through case management, and case management could sit in the community or it could sit in the court. We have case managers in our court support program who are the people who assess needs, and then they can be a case manager for that person, linking the person with supports, coordinating that care, meeting with the person regularly to encourage and monitor how they're going. And also we can do that through judicial supervision. Sorry. So thinking about what we do when we have our TJ glasses on, we think about the role of the legal actor, and the legal actor turns to the social sciences and says, hey, social sciences, what do you know about the issue that we're dealing with here? So let's look at the social sciences and do a little bit of a snapshot about what we know about offender rehabilitation. So the first thing we know is that change happens over time. It's not an event. The change is gradual and staged. So you can see immediately the disconnect between traditional court process, where someone might just come once and then don't do it again and on your way, and that's not aligned with a change process for someone with more complex needs. What we know is that there's lapses and relapses along the way in a change process, that it's not a linear process, that there's often 1 step forward, 2 steps back, 3 steps forward, 1 step back. And particularly we know that with alcohol and drug recovery, we know that with people who are maybe developing an understanding of their mental health diagnosis and acceptance and insight into that there's lapses and relapses along the way. Lasting change requires a change in identity, and this is the work around criminology around resistance, one from where someone sees themselves as a criminal or offender or a drug user, to other more pro-social identities, such as a good father, a hard worker. Change doesn't happen in isolation, it happens with others. So we are not islands, we need people around us. I talk a lot in court with people about scaffolding, that your people around you, you're a bit shaky, you're a shaky building, but the scaffolding, we are the scaffolding around you. You've got me, you've got your lawyer, you've got your case manager, you've got your alcohol and drug counsellor, you've got your mum, you've got your, that good friend from school that you've lost touch with, you've got you eventually your job or whatever it is around you. It's sometimes called recovery community or recovery capital. What we also know is that change is just not, as much as we as individuals may want to change, there may be structural barriers to impede change. And the big ones for us are poverty, stigmatization, lack of access to supports, racism. There are these structural barriers that impede a person as much as they want to change. And a big one, say, for example, is, you may want to change, but if you don't have a house, because we're in a housing crisis, you can't make change. And so how much do we put upon that person as an individual and hold them to account, when actually it's the structural barrier that is really causing them an issue? What we also know is that where there's trauma, substance abuse and other problem behaviour can be coping mechanisms, and we need to think about it as that, so that we understand what role it's playing for the person and what it means to take it away, and that can be quite confronting and also even dangerous in some circumstances. So that's what we know about what the social sciences tell us. And then the other piece that the social scientists tell us is the trans-theoretical model of the stages of change. that talks about the different stages of change and where people are. People before the court are often in that pre-contemplative or contemplative stage because they weren't expecting to be caught, right? So there's not like they've voluntarily booked themselves in and done the work, hard work to get into detox or residential rehab. You know, they've actually been caught. They're probably in full flight of everything, all the chaos that was going on, which is why they got caught. And they haven't really got to the point of, you know, I need to make some change. They certainly will articulate that, but the kind of deep motivation is not yet there. So most of our people who are coming before us are kind of in that space. And so what is our role then? Our role is to try to move them along those stages of change to preparation, action, and maintenance. And so then where does judicial supervision come into that? So in appropriate cases, what judicial supervision does is provide a level of accountability, so monitoring compliance with court orders. So that's kind of what I would refer to as that external motivation. So the person knows. So there's something, some people talk about, well, why do you need the judicial officer involved? Why do you need the court involved? Why don't you just refer them to programs? Well, the thing is, where someone's not at the stage where they're going to really have that motivation, the initial motivation, it can be an external one. You know, we know that, we see it. Sometimes it's the wife who says, if you don't stop this behavior, if you don't stop this meth use, I'm leaving you and I'm taking the kids, and that's enough. Often that's it, and even that's not enough. You know, the people we see are people who've been kicked out of home, whose mothers and father aren't talking to them anymore, who've lost their job. So, you know, having some external motivation, accountability, you know, and even to thinking of the role of accountability, I call it the Weight Watchers check-in. For those of you who know, that sort of, and all the apps now, behavioral change apps and things, you know, you can log your steps, you can log your food, you know, it's a behavioral change thing, having someone that you're accountable to. So it's a little bit of that external motivation. Other purpose, which I think is the more powerful purpose, because external motivation goes so far, because we know that, because even with the threat of jail hanging over their head, people still relapse. So external motivation goes so far, it plays a role, but what you really need to be doing is building internal motivation and supporting a person making that deep change and committing to change and moving them along those stages of change. And that, I think, is a very powerful role of judicial supervision. Not just us though, but we're working in a team. So this will be bolstering what others in the team will be doing, such as their alcohol and drug counsellor or their mum or whoever else is in their team. So we're not doing this alone, but we are really adding to that. So how do judicial officers do that? So again, what does the social science tell us? The social science tell us if we really want to support change, people need to feel in control of their own destiny. And that's where that external motivation only goes so far. And this is at the heart of any of the really deep thinking around therapeutic jurisprudence. If you look at the original works of Winnick and Wexler and works of Michael King, the need for a person to have agency, autonomy, voluntariness, self-determination, be in control of their own destiny. And we know that. We don't like being told what to do, us humans, but if someone says, what do you want to do right now? That's a whole different thing. We need to listen for and reflect back problem definition and change talk. So if someone's pre-contemplative, we shouldn't push them too far into action. You should do this, you should do that. You'll build resistance. So what the social science tells us is that you, in those early stages, you need to just listen. You know, are they identifying a problem? Are they talking about that they want to make some change? Listening for that and reflecting it back. Not taking it the next step. Oh, I hear you want to do this. so you should do this, this, and this. Just sit with it. Just say, so you're in custody right now, you're wanting to get out. You mentioned that you were tired of this life. It sounds like you want to make some change, and just sit with that. Setting goals and actions and building in accountability, again, that behavioral change, you set your goal weight, you set your, your check-in times, those sorts of things. Behavioral science tells us works. Strengths-based approaches, acknowledging strengths and praising positive effort, even small, makes sense. We feel like we're making progress, we build our confidence in change. A lot of people we're seeing have tried many things before. It's not like they've not tried giving up drugs, right? They've tried a lot. They've tried a lot of different things. They're depleted and they're lacking in confidence. So starting to identify strengths and praising positive effort. Acknowledging the systemic impediments, because again, you can't put too much on the individual. If they don't have housing, as I said, you need to acknowledge that. But at the same time, even within that narrow scope, you can say, well, what is it that you can do? You can't change that, but what could you do a little bit different? Well, I could call my housing worker every day so that if something does come up, I'm there for her, so that sort of conversation. The importance of hope. Hope is just so important. Hope and expectations, particularly for people in trauma, any trauma-informed practice. We'll talk about the need for hope. That concepts of connectedness and relatedness, the trust, what Michael King calls the ethic of care, authenticity, respect, those sorts of you're going to feel more motivated if you feel that you have trust in the person that is trying to help support that motivation. So a person who'd gone through drug court here recently, who's now one of our peer workers, said that someone asked him, was there something particular that a judicial officer said to you? And he said, well, it wasn't one thing in particular that stands out. He said it was more that what they were asking me to do was step away from a life I knew that I was actually good at as a drug trafficker, that I into another world that was unknown to me, that I was worried about. And because I felt that they were authentic, that they respected me, that they genuinely had a care for me, that I trusted them and I was willing to take that step with them. So there's something about that. And there's something about that, I think, with a judicial officer who's in a position of power, who is having that, well, if they care for me, maybe, I'm willing to, I'm worth something. Reducing stigma and pumping up dignity. So dignity is at the heart of TJ. And the dignity, the inherent dignity of the person. Stigma strips away dignity, makes us feel shame. We know there's lots of knowledge coming out now about how stigma stops people help seeking. It can be a big barrier to change. And so I say reduce the stigma. It's about the language we use. I don't say dirty urine screens or unclean screens. I say clear or clear screens. I don't call someone, a schizophrenic, someone who's experiencing a mental health issue, things like that. Language does matter because it's how people hear it and what they're already thinking, that they're not worth much. And so you've got to be really careful about how you're talking about things and really just pumping up the dignity of the person through just acknowledging them as a person, getting eye contact, all those sorts of things, calling them by name, spending some time with them, even in a busy list. Positive connections, including with professionals, can inspire hope. So this is this kind of loop. So positive connections can inspire hope, and then hope provides motivation to actively engage in meaningful activities, which in turn empower and build positive identity. So that's the loop. That's a little bit about what the social sciences tell us, how judicial officers might build and motivation and support change. Now, there's been lots of research. So, why, does this work? There's been lots of research in the specialist court settings that judicial supervision is a key component of, say, drug courts or mental health courts. There is something going on with the judicial officer. A lot of those studies have tapped into the concept of procedural justice, the idea, the work of Dr. Tom Tyler, that if you are neutral, you provide voice and respect and trustworthiness, that a person is more likely to comply, they're more likely to feel heard, and regardless of outcome, be more satisfied with the process and the outcome. So there's something about that, just that basic procedural justice. I think there's something a little bit more though that's going on, and there's some different researchers in our TJ community who are doing work around what are the other things that judicial officers are doing that may actually be what I call the secret sauce. I don't know what it is because I'm not a researcher, but I see it every day. There is something about the judicial officer connection with a person, about having expectations to that person, about having a really genuine accountability that's not just a you'll do this or whatever, but a real therapeutic accountability, and something about that ethic of care and the connectedness and the hope that then gets into that cycle. And I can see that happening. So that's there hasn't been a lot of work in the mainstream court space about this. This is a research area that's open for research. So is it just procedural justice, or is there something more going on? Okay, so what does this mean every day for my everyday TJ? So here's my tips for judicial supervision hearings. Remember the purpose of judicial supervision. You're not a counsellor, you're not their support worker, you're not their service, community service. You are a judicial officer, and so you have a role, and your role is very targeted. It is accountability and motivation. That's the role. Baseline, every interaction is about providing that procedural justice, the neutrality, the voice, trustworthiness. So baseline procedural justice, every interaction from the moment the person walks into court, what they see you doing with other people while they're waiting for their case, everything like that is really important. That's how I work every day. That's my baseline. Dignity, acknowledging the person, knowing their name, knowing their mum's name, acknowledging them as a human and giving them dignity, giving them choices, reducing stigma, as I said, being careful of your language, boosting up dignity, reducing stigma. So that's your baseline in every interaction, even if you're really busy. Then there's a little bit more about building that rapport. Now, obviously, there's boundaries. You're a judicial officer, you need to maintain neutrality, but a little bit of rapport, as I said, knowing mum's name, knowing their son's name, the new baby on the way, how's the baby going? Just I make little notes of that, and just so I can connect with the person so that they know I've remembered them. I'm showing that ethic of care. You seem really distressed today. Is there something we can help you with? That compassion. Assist the person to identify the problem. Don't tell the person the problem. Assist them, like asking open questions. What do you see the issues for you are? What do you think has led you to this? Assist them to articulate it. Don't tell them. We love, as judicial officers, we're very bossy. We love to tell people lots of things. We need to stop talking and asking more questions. So then active listening. This is the biggest skill, I think, really listening. And it takes a bit. You got to slow yourself down. Like I could be in a very busy list dealing with hundreds of cases, and, a judicial monitoring comes in. I've just got to take a moment center myself and take a breath and actually slow myself down. Now, I usually only spend about 6 minutes, 6 to 10 minutes with the person for a review hearing, because I know them, I've got my notes, I know what I want to focus on in terms of accountability and motivation for that session. So, I'm not spending a lot of time, but you need to spend a little bit of time. So you get out of that busy, I'm in a busy list mode, and just shift a little bit, center yourself and just listen a little bit, and reflect back and affirming any change talk. Remember, people are in those early stages of change, so you need to listen for those little hooks. I hear that I'll start off. How's your month gone since I saw you last? I've been keeping out of trouble. Oh, that's great to hear. What's your secret there? How have you been keeping out of trouble? Oh, I've just been staying home with mum and really helping her out around the house. I hear that your mum's really important to you. That's showing a lot of love for your mum by doing that. I bet she's really proud of you, and really that's a great help. Just listening for things where they're talking about the change that they're wanting to make, and just reflecting that back and affirming it. Supporting their autonomy, self-determination, their self-efficacy, guiding, not directing. I've done motivational interviewing courses, and that's really helped my practice. I don't do a pure form of motivational interviewing, but it's really stopped me telling people what to do and guiding. And I know that David Wexler wrote a piece a while ago called something like Guiding Conversations for Change. So it's that guiding, not directing. So asking open questions. What do you need right now is probably the most common question I ask in court. What do you need right now? I remember once this young man was surrounded by people. He had all his workers, he had this and that, and he had this program, that program, and they were all in court. And I said, what do you need? And he looked up through this mass of hair and he said, I need a haircut. And it's like, actually, he needs a haircut. And for him at that time, that was the most important thing. And, he wasn't going to do all the other stuff because he just needed a haircut. So, it's amazing, but I get really deep answers about what people need often. Like, people know what they need. So you just ask that simple question. And then you say, okay, well, what are your goals? And Dr. Michael King uses a really great, and a few of us use it, a goal and strategy sheet that we get the person to take away, fill out, step outside, fill it out, take it away, bring it back next month. Where they can work with their workers or their mum or whoever's helping them to do it. I also have one that's just a visual for people who are not great writers, where I'll ask them, what are your goals? And it's got steps on it, and I'll write their goal up the top, and then I'll write just their steps I'll do drawings along the way. So that's the sort of thing you can do, or you can ask their workers or their lawyer to do it with them outside of court if you're busy. So that's a really good tool. And then using those goals and actions to set expectations and hold them to account. So, in a gentle way, not, saying, well, look, last time you said, you thought you would do this, how'd you go with that? Like, and not then criticizing them if they haven't done it, but like, oh, so what got in the way of that? Oh, well, I lost my housing, and so I was focused on getting new housing. So it's like, okay, so do you still want to do that? Oh, yes, I do still want to do the psychological counselling. Okay, so what would be your next step? So that's the sort of conversation. More tips: be hopeful, set expectations for a better life. Expectations are huge. A lot of what happens to people is that we don't have expectations of them, and then they feel worthless. It's so important. Acknowledge that change can be hard. I often say, if it was easy, I wouldn't be here. We'd be out of a job. If beating addiction was easy, we wouldn't have any of this. And everyone goes, yeah, that's right. It's not easy. Particularly drugs like methamphetamine, opioids. It's really hard to beat those addictions. Alcohol is another one, really hard. But being hopeful that I often say, look, I've seen people who are in your situation who felt that they couldn't do it. They had a lot of ups and downs along the way, but they got there. And I've actually seen that. Like say, look, I had someone here yesterday who, they started off like you, but they just came in yesterday and said they've got a job. They got a new girlfriend, so giving people some hope, but acknowledging that it's hard. Being aware and acknowledging the system barriers. We talked about that. Just, this is hard. And it's not all you, there are some system barriers that make it hard for you. Build capacity to problem solve when there's challenges. So, you don't want to tell people how to solve their problems. You need them to learn how to solve problems for themselves. What could you do differently? A lot of the people I have around me maybe have not had really great parents because parents had their own issues, haven't had people around them who help them sort of problem solve. Sometimes people with cognitive impairments clearly, can be very problem solving. Executive function is it can be diminished. So, making it simple. What could be, sometimes people are just overwhelmed. If you're trying to cut down on drugs, you'll go through that, what they call the anhedonia, where you just feel depressed. And with methamphetamine particularly, that lasts for a long time. So you feel quite flat and can't find joy in anything. So people can feel a little overwhelmed, or if they've had a relapse, they go, I can't do this, and they lose confidence. And they often come to me and they walk in, I say, how are you going? They go, I'm not great. And it's like, okay, you sound like you're feeling a little overwhelmed. Am I reading that right? Yeah. Okay, so what is just one thing you could do to make a step in the right direction this month? Let's just pare it all back. Don't have to do your community work. You don't have to do this meeting, that meeting. What is the one thing? What you tell me, what is the one thing that will help shift you a little bit further? And they'll say, okay, I just want to get to my counselling, my drug counselling. Okay, good. Okay, let's just have that. Pare it right back. Acknowledging good progress, affirming and identifying strengths we talked about. Looking for shifts in identity and affirming that. So whenever I get something like, they say, okay, I'm helping mum out around the house. As I said, you're being a great son. You're being a really loving son. What did you do? What did you do since I saw you last? I've been hanging out with my kids. We went to the beach. Oh, wow, you're sounding like, that's great. That sounds like they would have had a great time. You're being a great dad, or I've got a job. Oh, they must, how's that going for you? Well, the boss is pretty happy. Oh, well, you're a hard worker. You must, so it's trying to just affirm some of those identity shifts. And planning for exit. So my thinking is that we keep people for us just for that bridge, how long that bridge has to be, and nothing more. Particularly where people, there's risks in being before a court, because particularly in our system, when you're often coming back before the court over time, you are on bail. And if you have even a small offence and break your bail by reoffending, it can mean you're back in custody and you lose your housing, etc. So there's some risks in someone being before the court. So you need to make sure that you exit people, and also that you're not building a reliance on the court. So you need to think about, okay, what do I want to do here? I want to get this person at the start. I'm thinking, okay, I want to get them stable enough to be able to do their probation or community corrections order. That might be, so I'm going to have them before me for 3 months, and I'm just going to get them a little bit more stable. I'm not going to solve all their issues. I'm not going to have them beat their addiction. They're probably still going to be actively using, but I just want them to be a little bit more managed, a little bit more stable, have a few more supports in place so they're not as chaotic, so they can do their corrections order. you know, that might be what I'm doing. Or I put them on a corrections order and I just want to see how they're going in the first little while, and then I'm going to stop, because it's not my job I'm not their therapist, I'm not their counsellor. I am there just to make sure they're engaging, have that accountability, build that motivation, and then step away as soon as I can. And the other thing is to schedule, if you can, and this depends on what court you're in, but schedule your judicial supervision hearings together. If you can, even if it's just like the first half hour of the day or something, so that you schedule them together so that and get others in. And I even get the ones who are doing well, and because I'm lucky enough to know that in advance with the reports that I get, and I schedule them first so that the ones who are struggling can see people who are doing well, and that's a motivating thing for them. So it's the power of peers. We actually in our drug court have peer mentors who play a really important role. We can't do that in our mainstream court. We don't have funding for that sort of program. So what I tend to do is try to use those little opportunities where others are listening to what's going on for other people as the peer group. And sometimes I might even call upon, if I've got someone who's doing well, who's actually there waiting, I might call upon them and say, do you mind, you know, just talking about what's worked for you? Now, so in terms of targeting, as I said, it's really important, even from an efficiency point of view with courts. High volume courts, in a mainstream court setting, you can't use these approaches in every case, but you can use them in some cases. And so, from an efficiency point of view, that's important. But as judicial officers, we're not just into the efficiency. That's a consideration, because justice, if you don't have efficiency, you get delay. If you get delay, you get other injustices. So that is a consideration, but also there's other considerations in why we would target. And that is first the risk principle from criminology, that offenders should only be provided with the dosage or the treatment level or supervision that corresponds to their risk of offending. So you don't want to have these approaches for low risk offenders, because the more you bring low risk offenders into the system, the more counterproductive that is, that you can actually increase their criminogenic risk. So you want to be aiming this at people who are kind of higher risk. I tend to aim it at people who are doing, you know, it's not a shop theft that they're doing, but they're getting drunk and beating up the guy at the store when they're stealing the bottle of bourbon, because they're doing harm in the community. So it's like, okay, I need to kind of be involved here. It's the same need, but the different risk in terms of the level of harm in the community.
Pauline, I did just want to let you know that we're about an hour in.
Okay, I'm nearly finished. Great. So proportionality, avoiding net widening. So that's important. As I said, the tendency is, oh, this person's got a lot of need, I want to help them. That's not our job. Okay, we're a court, we're judicial officers, but also we're involved in someone's life, the proportionality. We need to make sure the response is proportional. That's a legal concept. We don't want to net widen and bring people into the system who should be being supported in the community. Avoiding setting someone up to fail. Sometimes the system impediments are too great, and we're just going to have someone fail, and that's going to be debilitating for them. And it's also risky for them to be before the court for any longer than they need to. Sometimes less is more, even if someone has quite complex needs. And that can be really hard, because sometimes you could say, I just can't do anything here. I can't work with this person with these really complex needs if they don't have housing. Like this is not going to work. And that's really hard to have that tires magistrates out. Supervising for a reason and for the shortest possible duration. I've talked a little bit about that. And for us, looking at kind of what the data tells us. So community corrections orders, the first 3 months of being on a corrections order is the rate of where people fall over the most. and have the highest rates of contravention. So I focus my judicial monitoring hearings on those first 3 months when I put someone on a corrections order. And so I'm kind of guiding my targeting through what the data is telling us. All right, so that is everything there. We've got some time for some discussion and questions.
Let me just start by saying thank you so much, Pauline. You had originally said, oh, stop me at 45 minutes, and I couldn't because I was too fascinated by what you were saying. And I'm just astounded by the diligence and the amount of care that goes into every part of what you describe about your work. So I do thank you for that. I would like now to open it up to folks who have comments or questions for you. Folks, we've got like 20-ish minutes. Let's see. So, Amir? Amir Munir?
Hello.
Yes. Hi.
Thank you very much. Thank you very much, and thank you for having this wonderful session. I myself, being a judicial officer, have learned a lot out of this session. And I think these type of sessions really work to spread, the message of the TJ. So thank you to the TJ community and to my old friend, Magistrate Pauline Spencer. And I have heard the name of Michael King. Yes, I have been in interaction with him, but I think since long I'm not having any interaction with him. But good to hear all these things. Uh, I have one comment and one question. Yeah, my comment is that you have told about a number of barriers which you have uh, evolved to implement this TJ thing while judging in the court. That's great that you have taken steps to show that how you can work at the level at the mental level of the litigant or the person who is coming to the court to see how his or her problem is resolved or solved. That's a great thing. And I know in very I mean in shortage of time in the courtroom, these things are very difficult for a single judge or a judicial officer to implement, because what I see is that therapeutic jurisprudence is so far going on individually. So I am a practitioner, TJ judge or a judicial officer. You are a TJ practitioner, judicial officer. There are certain TJ, law teachers as Professor Wexler and Michael King and so many other people, Professor Yamada, Professor Michael King. So all are doing this thing of their own. But I am still seeing that we lack some institutional support or a mechanism where you can see that if a person is having something to be taken on TJ front, he or she can be referred to that TJ laboratory, you can say, where he or she can be provided TJ, you can say, TJ treatment. Anyhow, that's great. The other thing which I want to ask is now that in our country, language is a great barrier between the judge or the court and the persons who are coming to have the court services, all the defendants and all the plaintiffs and all the suspects, etc. So what I have experienced after learning a lot of TJ things from Professor Wexler and so many other people here, it is that I try to have interaction with the people coming to the court in their own language. For example, in Pakistan, people generally understand our national language, Urdu. But this is national language. Sometimes you need to speak with them in their local language. For example, Punjabi. In this Punjab province, mostly people understand Punjabi. So I try to talk with them in Punjabi language just to see the impact of my words, I mean the words from the mouth of the court directly reaching to the ears of the person who has to ultimately implement that order or that setting of the thing. So my experience is that when I use this language, when I remove the language barrier, I have seen that the people come back with, positive results. Otherwise, our system is English. We all write judgments and orders in English language. Litigation is in English. So many things are in English. So can you explain that how you remove this barrier? Because I understand that in Australia there are so many people who don't understand English. I think they are local aboriginal or something like that. How you people deal with them with respect to language barrier? Thank you very much, and thank you for listening me for a little
Sure.
longer.
Oh, thank you, Amir. It's a great honour to have you here. You do such amazing work, particularly your written judgments and applying TJ in your written judgments. So thank you for your comment and question. In Victoria, we have interpreters. So in the criminal court, people are provided free of charge with interpreters. So we have so many language. We're blessed to have a very multicultural and diverse community. So where someone is coming to court, even for a procedural hearing, whatever it is, meeting with their lawyer, an interpreter will be provided. So we work very closely with the interpreters. They come into court and they'll be talking with the person. I think what you're, to acknowledge the person, I often say to the person, because they feel shame that they don't speak English, I say, I see your language is, Arabic, Somali, dialect, or whatever it is. And then I say, well, my Arabic is terrible. And actually acknowledge that I'm the one with the deficit. With common languages, I do learn a few words just to, be able to say hello and thank you, and, just a little bit to be able to just show that connection, that dignity of the person. And often people who are coming in our courts, they'll speak 3 or 4 languages as you do. And so I'll say, I see your language is Arabic. Do you speak any other language? Oh, yes, I speak Italian and I speak and it's like, wow, like here's someone who's really, amazing. And I said, oh, well, I only speak English. I'm pathetic. So that's a little bit about what we do with the language barrier. And the other thing we do with our that I've started doing is I do for our First Nations community is an acknowledgement of country, like I did at the start of the session. So I do that at the start of court. Certainly in our Aboriginal sentencing court, we have a whole lot of, and in all our courts, we have all the flags, so the First Nations flags, as well as the Australian flag. And we have throughout the court building, our buildings have been, as our Koori Court unit says, Koorified. We've got artwork and carvings, and we've had smoking ceremonies and dancing and all these things that have happened. We just built a court where we have a huge bundle, the creator eagle, on the outside of the building. So just about using language, about using art and the court surroundings to actually make people feel safe, and particularly culturally safe, or safer. You're never going to feel culturally safe coming to a court, but safer. Yeah, so really great concepts.
For sure. I see David Yamada's got a hand up, and I know that Michael Perlin he intends to have a hand up. So I'm going to go with David and then Michael.
Hi, Pauline. As always, I really enjoy hearing you talk about how you do your work. And in fact, that's really of the many questions I'd like to ask, and the many things I will write to you separately about. The question of, well, oftentimes judges practicing in a TJ manner, their peers will say, and we've heard this before, I'm a judge, not a counselor, right? Or I'm a judge, not a psychologist. However, I think part of the real masking in that comment is that they don't know how to operate in that more personal mode. And whether or not I'm correct or not, I am assuming that there is a challenge for someone in your position between exhibiting the kind of authority you have to exhibit as a judge, while frankly being vulnerable enough to have a conversation with someone. Could you share some thoughts on how you've thought through that role as a judge, and have those thoughts progressed over time in terms of how you sort out, that balance of how you work with people in your courtroom appearing before you?
Yeah, great question. I came from community legal centres, so clinics, legal aid or defence type work, so poverty law. So I was used to working in this way, plain language, working in multidisciplinary teams. That was kind of just how I work. So I brought that to the bench. And at first I thought some of the formality of court was, disempowering, and but then sitting in court, I learned that you do need a certain amount of gravitas to both in terms of the matters we're dealing with, particularly, the harm that's been caused to, say, complainants or victims of crime, and having some gravitas, the accountability sort of side of things, that, this is not good what you've done. It's not the right thing to do to your fellow human being. Having that sort of gravitas, but also to control the court. Like if you get very informal, you can lose control. We're dealing with often people who have behavioural issues and can be quite violent, so you can lose control. So you need to have a certain degree of gravitas. But I must say that I think what Anthony Hopkins would talk about, the compassionate stance, has helped me, because people can see that, and the procedural fairness, that they can see that I have that neutrality, and they see that I'm giving people voice and trust, and they see that I have that ethic of care and that I'm wanting to assist. And so others see that, and it kind of permeates through the whole courtroom. And I even, when I've got a busy courtroom, I even see it in how people interact with each other. Like I had someone who burst into tears once, and a man came from behind and he sat next to him, put his hand on his shoulder just to comfort him. And then, someone had a struggling with a walking frame or something, and someone jumped up to help get the door, and I see this kind of kindness spread out. And so I must say, I've of course, like any judicial officer, I have some people arcing up, and, security has had to be called. But I must say, I don't think I've ever used, we have a duress button under the bench. I've never had to use it, even with people who were quite intense. The other day, I accidentally, when I had someone in our mental health court where we all sit round a table, so I'm not up on the bench, and I had someone who was being quite agitated, and he was very agitated with the prosecution, particularly had some persecutorial delusions with police, and was getting quite agitated and aiming it at the prosecutor. And I didn't do this on purpose, but I knocked over a jug of water. And it was a mistake, but it totally broke what he was ratcheting up, and it broke, and we all jumped up and we were trying to get the tissues and stop it going into the computers, and it just broke it, and he actually then calmed down, and we were able to move on. But sometimes you just need to get up and leave, and just diffuse the situation. But I very rarely have something like that happening.
Well, if I could just add a follow-up comment, what you've just said is you've demonstrated really in a very different way the power of a judge to model behavior for others. And that's, I think, part of the power of this approach, right? Because the trial court judges have so much power to send those messages, not only to litigants and witnesses, but to lawyers in terms of how you comport yourself in a legal proceeding. So I think a lot of our answers in what you folks do on a daily basis. So I'll
Yeah.
stop.
And I think this is one of the things too, in talking with court administration about this sort of approach, it is actually assists in case management. My colleague who's now retired but still working a little bit, some of you may know Jelena Popovic, who was a Deputy Chief Magistrate, is a firm believer that a TJ approach actually assists in case management, because if you can get things moving more smoothly, you can move things along. And also people who might be really anxious about coming to court and don't turn up and then have warrants issued for their arrest continually, she would often keep those people before her and say, look, next time you're going to see me. And then they know that they trust her, so they're going to come. Whereas they get anxious and then don't come the next time. So I think there is an efficiency dividend in this sort of approach.
Thank you.
Absolutely. Michael Perlin.
Pauline, as always, it's so wonderful to hear you. But I have to start out by saying when I started out as a public defender, one of my older colleagues told me, he said, if things are absolutely desperate in court someday, knock over the water pitcher. That'll distract you, but that's a card you can only play once. And I haven't thought of it in all these years. I love hearing you, Pauline. I love what you have to say. And my first thing, I actually have two things to say. My first is a nudge. I would love you to write up basically what you said in your PowerPoint, plus something about vulnerability for the Judges Journal, which is a US-based publication. I have no connection with it at all, so that American judges would see it. Because your approach is so antipodal to most of the judges I have seen in problem-solving courts in the US. Most of whom are former prosecutors. Even you said, I'm a former legal aid lawyer or whatever. I was in the public defender in the public advocate's office for 13 years. And so can't imagine how many hundreds of lawyers went through the doors. Only 3 ever became judges. 80% of the judges are from the DA's office. And that's, but your writing about this, I think, would just be amazingly valuable. The other thing was this: when I was listening to what you had to say, I had never heard you say this before, because it just jumped out at me, about active listening. When I started teaching, it was almost 40 years ago. That was the first thing I learned as a clinical professor, to teach my students how to listen actively to their clients. I have never seen a word written in the literature about judges in problem-solving courts needing, and there's all sorts of literature on that. I mean, thousands, I don't write about it, but there's thousands of articles probably. The need for judges to do active listening is so very, very important. I want to be thinking about it all night, for real. And I would just love for you in this article that I'm sort of nudging you to do, gently, to talk about that, because that would be such a aha moment for so many people, and you would be doing such a service to colleagues all over. Thank you so much.
Thank you, Michael.
Thank you, Michael. Anyone else have any last questions? Oh, David Wexler, I see your mouth moving, but I think you're on mute. Maybe I can unmute you. No, I can't.
Okay.
Oh, there we go.
Okay. I had a heck of a time getting on here.
But you're here.
I've been on for virtually the whole time on my little phone. But I didn't think I was going to make it at all, but I have made it for virtually all of it. And I thought it was terrific, and terrific also seeing everyone who's here today. And so I thought it was a great presentation, and very important. And yes, judges have been talking about active listening. Michael, I don't know where you've been about that. They have been
Sleep, I guess.
talking about that. But anyway, I'm just really, really pleased that I made it. I tried to make it on my computer, but it was just such a difficult time. But I'm really delighted to be here, to see everyone here, to see Stella Matis and Judge Amir and everyone. It's been really wonderful to see it all. So thank you very much.
Thanks, David. Great you could make it.
Yeah.
We've got some questions just in the chat there, Shelley, from Vanita.
She's left, unfortunately.
Oh, okay, unfortunately. All right.
But I mean, it was interesting. One of her questions was around trauma-informed judging and whether we knew of any resources. And certainly there's that fantastic new book on trauma-informed lawyering that Kim Wright and some other folks have come out with. But yeah.
There is on the Mainstream TJ blog, which I will put up in the chat, in the resources section. There is a for judges, there is a link to some trauma-informed work. So I will put that in the chat.
Oh, that's fantastic. And I'll share that with Vanita. Yeah. Wonderful. Pauline, we have a couple of minutes left, and in the absence of anyone, I don't want to take time if someone else has a question, but I was curious, in Canada, and you probably actually know more about this than I do, but we've got this concept of GLADU courts and the idea that when sentencing, judges should take into account specifically the circumstances of Indigenous individuals. And I wondered, because I know in the Australian context, there's a large population of Indigenous peoples as well. And I wondered if there is an analogous set of principles operating.
Yes, there is a case in our High Court, which is the highest court in Australia. So your Supreme Court equivalent, called BUGME, BUGMY.
I'll find it.
That in the chat. I can send you the case, Shelley, explicitly, but BUGME, High Court of Australia. If you Googled BUGME, High Court of Australia, some lawyers have now done a BUGME bench book as well, which sets out a whole lot of resources. So that case was Mr. BUGME was a First Nations man, and that case stands for the proposition that where you experience disadvantage, serious disadvantage in childhood, that the impact of that doesn't diminish over time once you're an adult, that it's something that is carried with you, and that it can count towards reducing your moral culpability or level of responsibility for the offending, and sentencing principles such as deterrence, denunciation and punishment. Even though it was actually, the lawyers did talk a lot in their submissions, I understand, about GLADU, and it was a GLADU type case that was being brought. It was the High Court decided it broadly, not just for First Nations persons, but more broadly for people who have experienced disrupted or disadvantaged upbringings. And so the work in the BUGME bench book, or BUGME, it's a BUGME resource that has been put together for the lawyers, talks about a whole lot of different things like sexual abuse for children, exposure to family violence, neglect, and how these things can operate upon a person going forward, so that lawyers can make submissions about it, as well as the impact of colonisation and intergenerational trauma for our First Nations communities. So, and we have a GLADU style report pilot happening in our county court, which is the court just up from us in terms of that in the hierarchy. So Magistrates Court, County Court. There is a GLADU style report for First Nations persons being piloted here, so that that court would get more detailed understanding about that person's history, their family history, the impact of colonisation upon them for the sentencing process. So that's underway.
Great. Thank you so much. I think that actually takes us to the end of our time. I thank you all for joining us. And thank you, of course, to Pauline for such a fantastic presentation. Again, I'm so happy that it's going to be recorded and that folks who weren't actually able to be here today can access it. So I will definitely get that word out once I've got it, onto YouTube, and please share the word when I send that out. So thanks, everybody.
Thank you, Shelley, for
Thank you.
hosting.
Thank you,
My
Shelley.
pleasure.
Everyone.
Take care.
Thank you so much. Thank you so much.
Take care.
Thank you if I'm still talking. I don't know.
You are